Hello, everybody, and welcome to a special edition of the Selig Speaker Series with the Selig Sports Law and Business Program at the Sandra Day O'Connor College of Law at Arizona State University. We decided to have this very special installment because it's been a big week in college sports. Namely, the Supreme Court of the United States ruled on a very big court case involving the NCAA. The name of the case is Alston versus NCAA, and there's been a lot of attention surrounding this case for several years now, but particularly the decision that just came down a couple of days ago. And we're joined today by our executive director of the SLB program, Glenn Wong, who will offer some of his insights on the NCAA, on the results of the case, and what are some of the implications of the future. So thank you so much for joining us, Glenn.
I appreciate it, Aaron. Thank you, and good morning, everyone. As Aaron said, this was a very, very important case that got handed down on Monday by the United States Supreme Court. To give you an idea how long it's been 37 years since the last NCAA decision or court case went to the United States Supreme Court. That case was called Board of Regents, and it had a significant impact on what has happened between 1984 and 37 years later to 2021. So I anticipate that this decision will be also very, very important. The couple key points about this court decision. Number one, it was a unanimous decision, 9-0, and the opinion was written by Justice Neil Gorsuch. Couple key points is that it affirmed that the NCAA is subject to the antitrust laws. It affirms that the NCAA cannot regulate education-related benefits. And it also rejected the NCAA's request and argument that it should receive some special dispensation from the antitrust laws. So therefore, it should be treated like any other business organization, sport and non-sport. So those are some of the key things that the court talked upon, and I'm sure we'll elaborate on it earlier. But obviously, it's a very, very important decision. It's going to have some short-term impacts, and it's going to have some long-term impacts.
Glenn, let's talk about some of those impacts. And the first question that I have in terms of impact of this case moving forward is, what does this mean for student athletes, both long-term and short-term?
What it's going to mean for student athletes is that the NCAA can no longer regulate education-related benefits. So let me give you some examples of some things that fall within what is considered education-related benefits. It can be computers, musical instruments, exchange programs, paid internships, undergraduate and graduate education, vocational education, really anything related to education. So think about what the NCAA has always said, that they're student athletes. So what this decision says is the NCAA cannot make rules governing any limitations on that. So therefore, what that does is going to shift that responsibility to the schools and the conferences then to set those rules.
So you mentioned educational related benefits, and you gave some examples. Is there something that the NCAA had in mind, or that member institutions had in mind regarding this case? There was obviously some conflict over something in this case. When they're talking about educationally related benefits, what's really the issue here?
Well, the issue goes back to what was originally brought in the district court, and what the plaintiffs were asking for was really to take the NCAA rules off everything, and that includes compensation, that includes pay for play, and also the education related benefits. They really wanted what the Sherman Antitrust Act is designed to do. It was basically asking for free and open competition so that athletes could get their market value with respect to everything from education to compensation. The reason why it's ended up with just education-related benefits is the district court judge decided not to allow the compensation of the pay for play for student athletes, but did allow the education portion. In part, I think, based on the fact that the NCAA emphasized that what is different in college athletics from pro sports is the fact that they're student athletes and that they're getting an education. So that's why I believe the court allowed really the market value to set what those education related benefits are, and not just limited to the typical scholarship, room, board, and tuition.
So this seems like a pretty narrow ruling then. I know there's been a lot of editorial around this next question that I'm going to ask you, but does this mean that NCAA student athletes can now be paid for playing in the sports that they compete in?
Well, first of all, Aaron, you said the exact word I wanted to make sure that people understood, and that is narrow. This decision is very, very well written, and it is something, and this is, I think, something that lawyers understand, but just wanted to be sure that the people who don't have a law background understand is that the Supreme Court, when it makes a decision, is limited by the issues that are decided by the Court of Appeals, and in this case, the district court. So it is a narrow decision, and technically, the court did not address the pay for play issue because the district court did not address that issue.
So there's been a lot made about this concurring opinion that Justice Kavanaugh wrote, where he pretty much eviscerated the NCAA model. And the NCAA retorted, well, that's just his opinion. This is actually a very narrow opinion from the court. His concurrence really doesn't carry that much weight. I want to get your sense, Glenn, as to what you think about that concurrence and what consequences it has, if any, for the NCAA moving forward.
Aaron, that's a great question. A lot of people are very interested in the Kavanaugh decision. And for those of you who have a chance to read even part of the decision, you should read the Kavanaugh decision. So first of all, let me say that the opinion was 9-0, which means that Kavanaugh joins the majority decision. The concurring opinion is something that's used in Supreme Court decisions where the judge or judges do not agree in full on the reasoning of the majority of the court. So what Kavanaugh has done here is that he has, in effect, addressed the other issue that the other part of the Supreme Court did not address, and that is pay for play. And he clearly says in his 5-page concurring opinion exactly what you said, Aaron, is that he said that the NCAA is not above the law and that it um, should be treated like any other business, and that college athletics is no different than any other business and should not receive any kind of special dispensation. So I think what that does is that the other important thing is that a concurring opinion is not precedent. So from a technical legal point of view, a future court will rely on the majority opinion. But certainly people who are arguing cases will point out a concurring opinion, and that can be important. So, in trying to figure out or think, and I don't know, but to in Kavanaugh's case, but in general, judges write concurring opinions to either guide people in the future, guide future courts, guide future litigants, and also to encourage legislatures if it's an issue that might be handled by legislation. So Kavanaugh clearly felt very strongly about this case, much more strongly about this than the other justices, since he was the only one. But that's the purpose of it.
So, do you think, Glenn, that invites uh, more litigation moving forward, challenging the NCAA's concept of amateurism? I think a lot of people look forward to this case shutting the door on a lot of this stuff and getting some resolution. But it seems like his concurrence invites more litigation. What's your take on that?
Yes, I agree with you, Aaron. I see more litigation coming down the road. And I know that's to some extent that's a negative, but the Supreme Court didn't address the other issue. And what Kavanaugh has done is he's basically set up a roadmap for future plaintiffs. I think when you see the arguments in future cases, it's going to be a combination of the majority opinion and also Kavanaugh's opinion.
I want to get back to what you spoke about earlier at the district court level, where Judge Wilkin in California had addressed this larger question of what athletes could be compensated, and her holding was ultimately narrowed to these educational related expenses. Why not all the other stuff? Why did she hold the way that she did just to educational related expenses being allowed, but not all the other compensation that essentially would allow for pay for play?
She distinguished. She had in mind distinguishing college athletics and pro athletics, and that was the basis for her, in part for just dealing with the education related expenses.
Glenn, you spoke about the concurrence and how it could possibly inform governments and legislatures moving forward. Let's talk about a big thing that the United States government and several state governments seem to be focused on in regard to the NCAA, and that's this concept of name, image, and likeness. How does this decision interact with that issue? Are they two totally separate issues, or will this influence those pending laws that will go into effect in about a week here in some states?
They're really two different issues. The In terms of direct impact, this court decision will not change the name, image, and likeness issue. Yet, I will say that there might be some impact in an indirect way, and that is that obviously legislators are seeing what's happening here, and they may take a different stance on this, given what I think those of us in the industry knew how this operates, but this um, really lets legislators and the general public know about this. So one of the downsides of the NCAA taking this to the Supreme Court is that this has generated a lot of news and a lot of the general public, which really wasn't following this as closely as before, having a Supreme Court justice basically say the NCAA model is broken.
Not not good news for the NCAA in this latest news cycle. Let's talk about Title IX, Glenn. How will this decision impact Title IX on campus, specifically the disparities between the already existing disparities between women's sports and men's sports on campuses, and how schools are now allowed to provide educationally related benefits to student athletes? What do you think the impact on Title IX will be?
Well, obviously, Title IX is very extremely important, and I think institutions and conferences and the NCAA are all going to have to take that into consideration. So here's what's interesting is that the Alston case is a class action lawsuit, and it was brought on behalf of men's and women's basketball players and football. So when you look at those numbers, as I'm sure you know and everyone else knows, those numbers don't balance out. So technically, if the organizations and institutions want to follow the court decision, then they would just satisfy and take care of the education related benefits to men's football players and women's and men's basketball players. I think both for equity reasons and also, just looking at sports more fairly, that the NCAA is probably going to have to, or probably going to end up dealing with making sure that there's proportionality, and that means that I think other sports are going to be included and not just those three sports.
Glenn, I'm going to ask you to play economist for a second here. There's already this dearth that exists between the different members of the NCAA, whether it's D3 to D1, within D1, even within the autonomous five, there are some pretty significant financial disparities between, some of the richer athletic departments and some of the ones that just get by or largely operate at a loss. How will this decision impact those financial disparities, and what do you think the NCAA could do to help preserve a product where there's some parity in sports and competition?
That's a great question, Aaron. I've been concerned about the financial disparities. From what I've seen, they've grown recently over the years, and I think that this will continue given this court decision. And here's why. Let's take the education related benefits. I think there's certainly some schools who are going to want to do that, and they're going to make it part of the recruiting packages for student athletes. So they'll say, in addition to the scholarship, we are going to be able to offer you a paid internship. And I think that when you get beyond the Power Five institutions, and even some within the Power Five institutions, that they're not necessarily going to have the ability to fund those things. So I do think it's going to increase the disparity between the schools.
Glenn, let's talk about the future. Um, what do you think, given this holding, college athletics will look like in about 10 years?
That's a great question. I'm not sure I know the answer to that. I'll throw some different ideas out there in terms of kind of what I see. I think that there's going to be more power in the conferences and less in the NCAA. What I don't know is, because people have speculated, will there be another division or another tier set up for basically for the Power Five schools, give or take, but some kind of group. And what that would allow to do in theory is that then those schools will compete, and those schools are more likely to offer the higher educational benefits, and they'll be more geared to what their finances look like. The other model that I've heard talked about is to change the governance so that it is sport by sport, as opposed to what it's set up currently. The other kind of change, just to throw out there, I know this is a dirty word, but it's collective bargaining. So collective bargaining is something that will solve the legal issues, because the model for this is professional team sports. And what the challenge is for the NCAA, as you can see from the Alston case and many other cases, is the antitrust argument. And what collective bargaining does is that it sets up the players through a union to negotiate on behalf of all of the student athletes or players in this situation. And then something is generated called a non-statutory labor exemption, which basically shields this sport, in this particular case, the NCAA, from antitrust cases. So then it becomes more of a bargaining situation. So from a lawyer's perspective, that is something that is, I guess, some people have referred to as a get out of jail card for the NCAA. But the other part of this, and I know this is true, is that I heard that the Division I athletic directors are like close to 100% against that, and it's because they see, and it goes back to the original case, they see the argument of trying to distinguish college sports from professional sports. And they see the move to collective bargaining as just starting down the slippery slope of making college athletics look just like professional sports. So while that's a clean and helpful legal decision, then I don't think that's going to happen. So let me tell you kind of what I think might be some ways to address this. I think one approach to this for the NCAA would be to look and say, if we were in a collective bargaining situation, what would it look like? So, in other words, what's going to be a fair amount to the student athletes? And I put that between somewhere between 0 and 50%. The reason is that the pro athletes get around 50% when you average all the professional team sports. I won't say they are at zero because they do get scholarship room more, but somewhere I don't know what it's going to be, 25 to 35%. So I think what the bottom line is that the NCAA wants to be able to present some things in a non-collective bargaining degree fashion that they can say is fair to the student athletes. And then they maintain control of it that way. But at the end of the day, the student athletes can look at it and say that's fair. We understand that. And so what that means is now how do we increase those things while trying to maintain um, no pay for play. Um, one thing would be to really increase the amount of the education benefits, and right now I think that the talk is about $6,000. One way to change that and get more to the benefit of the student athletes is to uncap that or make it very large so that someone, if they wanted to go to law school or wanted to go to medical school, would receive all of that. Another way, and this isn't directly involved with the NCAA, but one of the things the NCAA can do, I think, is to flip and encourage the name, image, and likeness. And the name, image, and likeness will put some money into the athletes' pockets. And frankly, what it does is it allows the ones who are most disadvantaged, which are the star athletes, to get more of the money. The advantage of using that as part of their plan going forward is that's being paid by third parties and not the NCAA. So those are some starting points of just things to think about, but I'm not sure where it's going to all be headed.
Well, they probably need to get you on the phone, Glenn, to help implement some of those starting points. Do you think that this decision is, I've seen a lot of this in editorial as well. These are the cracks in the foundation of amateurism and the NCAA as a whole. Do you think this decision means the end of the NCAA, at least within our lifetimes?
There are some people who think that it is the end of the NCAA. I'd have to say I'm not sure. I'm going to take a Michael Wilbon here. I'm going to pass, but that's certainly a consideration, and they're under significant pressure, and it's going to be interesting to see whether they disappear or whether there's significant change. I don't think it's going to be status quo. I think that's very clear.
Another economics question for you, Glenn. Where is this money going to come from? For those watching this interview today who are not familiar with the financial structure of a lot of athletic departments, most operate at a loss. And college athletics is actually not the lucrative vehicle that I think a lot of people think it is. There's a lot of redistribution of that big television contract in men's basketball. The NCAA doesn't handle anything from the college football playoff or the bowl system. What does this mean for how schools are going to fund these educationally related benefits with some already tight budgets? Where do you think that money comes from?
Aaron, I'm just wondering, is there any accident that the college football playoff is talking about expanding? I have no proof of that, but the conspiracy theories would say they're looking down the road. They're looking at possibly doubling the money they get there. That's certainly not going to help the others, but certainly it's going to help the 64. And there is some sharing with the other football conferences. I don't know if that, obviously that's not going to help the basketball schools, but I think that's the start of some of the thinking in terms of where does the money come from.
That's great. That's a great point that I honestly hadn't thought of. You know, I've always thought that one of the biggest problems in this area and what has maybe accelerated a lot of these issues is the exponential increase in coaching salaries over the last 20 or so years that have really highlighted some big disparities between what coaches earn and what the student athletes who play on the field earn. And I've always thought that the NCAA should try to seek an antitrust exemption, a limited antitrust exemption, just to cap those things, because that would free millions of dollars that could be redistributed in other ways. What are your thoughts about revisiting capping coaching salaries that, in my opinion, have just grown out of control?
Well, first of all, I agree with you on the coaching salaries, and I would also add to that the facilities. The facility, um, you know, arms race is just it's just amazing. It really struck me when when I look at some of those college facilities and look at the NFL facilities, and the college facilities are better. And it's because these schools are making a lot of money, and you know, they, a lot of them are state institutions, so they don't really have any other place to spend it. So they spend it on facilities and they spend it on coaching salaries. And I'm hoping that, in addition to the revenue generation, that the colleges at least slow down, if not cut back on in terms of salaries and facility renovations. In terms of the antitrust exemption, I know that has been raised. In fact, I believe that the NCAA was continuing to try to get that up until the time of the recent NIL legislation. I think there has been some talk and various people who have actually advocated that's a good idea. And I would say that to that extent, if it was just the coach's salary, it's a good idea. But I think the concern of people is that that it would lead to other things, and that along this special exemption type of thing, which frankly the NCAA has been arguing since the 1984 court cases that college athletics is special and should not be subject to the antitrust laws in the same way as other businesses. And I think that there was some reluctance to even begin to go down that path of even a limited antitrust exemption.
Glenn, if you are one of the individual member schools, and let's focus on the Power Five, it's going to have a big impact on the autonomous five schools. What are you doing right now as an athletic director to brace for this holding and its results? What are you doing to implement that's going to cause the least amount of pain for your athletic department?
Well, those athletic directors are really under a lot of pressure right now, and a lot of potential change. And the only ones I think that have a tougher job will be the compliance people, given the change of rules and the gambling and everything else. I think what the athletic directors are doing is that they have to, and they probably have some experience from this from the COVID pandemic, is they're planning multiple scenarios in terms of what might happen. So that's the big picture. What I think is going to happen. Let's go back to the education related benefits, to use that as an example. Um, I think the first step with what is going to happen and the timing of when the student athletes are going to get the benefits will be that the NCAA will go back to the district court in California and ask for some clarifications on their decision relative to what exactly is defined as education related benefits. And then I think, and the process according to the court will be either schools or conferences then make up the rules with respect to education related benefits. And I think what's going to happen for those schools that are in conferences, that they'll be handling at the conference related level. So I think one of the things that's going on will be to, at least in terms of the education related benefits, will be to go through the various laundry list of what we talked about, our potential education tethered benefits, and then decide which ones and then how much. And they're going to have to go through that exercise because that's going to then translate into kind of what is going to be their budget or what's going to be their potential cost.
Glenn Wong, Executive Director of the Selig Sports Law and Business Program at Arizona State University. Glenn, I see a textbook in the background there that says Career in Sports. Um, let's talk about that here as we're wrapping up our conversation. What advice do you have for somebody on the front end of their career trying to get into college sports or people who are already working in college sports? How will this decision impact them, and how can somebody use this decision to make themselves valuable to a college athletic department or a conference, and how can they distinguish themselves in ways that will help their career in this industry long term?
That's a very good question, Aaron, and obviously one that we talk to our students about. The reason that we have our law courses in our program is both to teach people about the law and also for our students to see the important pieces of legislation or court decisions which may impact the industry. So, one of the things we've talked about today are where some of the issues are going to be and what some of the increases are going to be. So, one thing that students should be looking at is opportunities and where there might be some growth. And obviously, they have to also consider whether they're interested in it, whether they have the skills to do that. But certainly that is an important thing to do. So, for example, given this, and I mentioned this earlier, I think there's going to be many more opportunities in the compliance area. And I think with name, image, and likeness, there's going to be people who are going to be needed in technology and social media and rules relative to that and intellectual property. So the importance of following this is not only to understand where the industry is going, but then to translate that into how is it going to impact them. And for those who are starting off, then I think that's also going to help them when they're in a leadership position. As our program is trying to do, it's saying that the business and law aspects are very important. So they're going to be able to, if they have aspirations to go higher in college athletics, is to map out their career so that they're working in areas that are going to eventually allow them to move up in that organization and hopefully potentially lead that organization.
Glenn, this has been a wonderful interview and a wonderful conversation with you. I do have one last question. Hypothetically, the Division One NCAA board calls you and they say, Glenn, we need you. We're going to pay you a bunch of money to get some of your advice here on how to deal with all this mess that has resulted from the Alston case. What's one piece of advice you'd give the Division One governance on how to proceed forward?
I think the advice I'd give is that I would make sure that both the athletic directors and the student athletes are more involved in the decision making process. I believe that there's some disconnect between what's happening at the presidential level and the executive director with the athletic administration and the student athletes, the people who are running the enterprise. As an example of that, I would tell you that there was great surprise when Mark Emmert had his contract extended, and a lot of the athletic administrators were very surprised at that, and I think that's an indication of the disconnect there. And I think there has to be a way for them to connect that because I think that's very important for the people who are running the enterprise and the people who are really participating in the game to have their input in a meaningful way, not just a committee, but a vote at the table, a seat at the table is very important in terms of moving on.
I 100% agree, Glenn. Thank you so much for your commentary, for your insight. I think you've shed a lot of information and light on something that's tough for a lot of people to unpack. So we appreciate your time devoted to this issue and for spending some time with us in this special edition of the Selig Speaker Series for our listeners, our students, all our stakeholders. We really appreciate you, Glenn. Thank you so much for spending time with us.
Thank you, Aaron. It's been a pleasure.
And thank you all for joining us today. We really appreciate you tuning in to this special edition of the Selig Speaker Series. Please follow our social media channels. Please follow Glenn's social media channels to be up to date on the latest developments in sports law and business. And until next time, we appreciate you and we hope to see you at future events. Thank you.